You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients.
Hello, everybody. This is Carol Laham. I'm a partner in the election law practice at Wiley Ryan. And with me here today is my colleague, Rob Walker, who is also in our election law practice. And today we're here to talk about the LD 203. So for those of you who are already shaking your head, I'm going to ask Rob, what is the LD 203 and why are we talking about it now?
Thanks, Carol. Well, yeah, for any of you who have not yet had the obligation, and I will say pleasure, of filing an LD 203 report, it's a form required by the Federal Lobbying Disclosure Act. We'll call it the LDA as we go forward here. And this report discloses certain contributions and expenditures and requires certain congressional gift rule compliance-related certifications. It's a report filed semi-annually, and that means, and I have to always remind myself of this, twice a year. It's got to be filed twice a year, both by registrants, that is, organizations that employ in-house lobbyists or lobbying firms, so both by registrants under the LDA, but also separately, an LD 203 report must be filed by each individual lobbyist listed or required to be listed by a registrant on their other LDA forms, such as the LD1 registration form or the LD2 form. And that's important. Yes, the lobbyists who are listed have to file it, but if you're required to be listed and you're not, you still technically and legally have the obligation to file here. So one reason we're talking about it now is because the reporting date for the next LD 203 report is coming up. They have to be, as I said, filed for each semi-annual period, and that would be January 1 through June 30th of each year, and then July 1 through December 31 of each year. So they're due 30 days after the end of that period, unless that date is not a quote-unquote business day. If that's the case, they have to be filed on the next business day thereafter. So, for example, as this podcast is airing originally, we're coming up to the end of the first semi-annual period for 2022 on June 30th. 30 days after that date is going to be July 30th. That day in 2022 is on a Saturday. So the due date for the next LD 203 report in 2022 will be August 1, Monday, August 1, 2022.
Okay, everybody got a break this year.
Yeah, they can spend Sunday doing the report.
All right, before we get into the details of the LD 203, can you just give us a quick overview of the history of when and how the LD2 reporting requirements came into effect?
Yeah, the LD 203 reporting requirement was created and imposed by the Honest Leadership and Open Government Act of 2007.
AKA HLOGA.
Yes, the mellifluously named HLOGA. And that amended the Lobbying Disclosure Act of 1995. So that was signed, came into effect in September of 2007. So we're coming up on the 15th anniversary of that. And HLOGA, as you said, as the act is known, also included changes to the frequency of reporting of lobbying expenses activities from the previous semi-annual basis to the current quarterly basis. So the LDA amendments done through HLOGA, obviously, as we've already said, included institution of the LD 203 reporting requirement. And these amendments were motivated largely by the scandal involving and relating to lobbyist Jack Abramoff in 2005 and 2006. the reaction to that scandal created a climate conducive and in some ways mandating almost a push for greater transparency in federal lobbying, and also for tighter restrictions on gifts to members and staff of Congress. So that's why we have the LD 203 report.
So we can thank good old Jack for this. That's what you're telling us?
As we can for many of the amendments to the Lobbying Disclosure Act.
All right. Okay, so let's get down to the actual form itself. I think you've talked a little bit already about who has to file. So if I'm correct, you said it's the entities that are registered to lobby, as well as the individuals who are identified as registered lobbyists. Is that correct?
That's right, or who are required to be identified as lobbyists. If someone's not on an entity's form, but they should have been on there because they met the requirements, they passed the two-part test for who was a lobbyist, they have the obligation, even though they weren't listed, so legally they have the obligation to file the LD 203 report.
Okay, well, that's a technicality that I'm sure absolutely nobody follows, but we're here to tell you what the law is. And the law is that if you should have been on the form, you should also file this LD 203.
That's right. It's like taxes. They'll get you for not filing the LD 203. Yes, it's in the weeds.
All right. So how about somebody who actually had been listed as a registered lobbyist and leaves the registrant employer? Does that individual have to file the report?
Well, I guess the answer to that is it depends. So if a lobbyist has left an entity registrant and left employment there during the semi-annual period, but was active for that registrant as a lobbyist for any part of the period, they're still going to have to file an LD 203 report, even if they've left employment. But, just walking out the door and packing your stuff up and leaving is not going to eliminate your LD 203 reporting requirement unless and until your employer, the registrant, delists you, or to use a more descriptive term, terminates you on their quarterly LD2 report for the relevant quarter. And that is done, to kind of go outside the LD 203 process for a minute. That's done and can only be done by listing the former lobbyist's name on line 23 of the information update page of the LD2 report for the relevant quarterly period. And just one thing to point out for lobbyists who leave a lobbying firm and where that firm represents multiple clients, this delisting has to be done for every client for which the lobbyist was previously listed to make the obligation to file the LD 203 report go away for that lobbyist at that registrant.
Okay, so I'm a little confused, and I think maybe the audience might be too, since we get lots of questions about this. So the LD2 is filed on a quarterly basis, so right. Just talking about the upcoming quarter, the next report is due on July 20th.
Right.
So the employer has to identify the lobbyist as not going to be lobbying on behalf of that employer in the future.
Right.
And then they have to delist them in the lobbying disclosure system? Is that what you're telling us?
Well, on the LD2 report, there's a place to identify that person who is no longer going to be active as a lobbyist.
Okay.
And that is at line 23 of the LD2 report.
All right. So once they've done that, that potentially ends the obligation of the lobbyist from filing an LD 203. Is that what you're saying?
Yeah. So let's look at it a little more concretely.
Mm-hmm.
Suppose a lobbyist is active as a lobbyist for a registrant in the first quarter or was active in the first quarter of 2022.
Mm-hmm.
And they're listed on the LD2 report as a lobbyist. And then in the second quarter, it's clear that, say, that person has either left that organization or has not lobbied in that quarter and is not going to lobby in the future, either because they've moved somewhere else, other duties in the organization, or they've left the organization entirely. So they were listed as a lobbyist in the first quarter. Let's say they are delisted on the LD2 for the second quarter of 2022. Comes the due date for the LD203 report for the first half of 2022. That lobbyist is still going to have an LD203 reporting obligation for that registrant themselves, based on their employment for that registrant. They're still going to have to file that report for this first half of 2022. But since they were properly delisted by the registrant, in the next quarter and going forward, the lobbyist will not have an LD203 reporting obligation in connection with that registrant.
Okay, so I think I get it. So if somebody is delisted, that will end their obligation. But if you aren't properly delisted, then your obligation to file the LD203 continues until somebody does delist you. Is that what you're saying?
That's right, and that can cause headaches, let's put it mildly, for both the individual lobbyist and for the organizational registrant. Because if someone is not delisted, the system, the Lobbying Disclosure Act system, which is overseen by the Clerk of the House and the Secretary of the Senate, is going to keep expecting an LD203 report from that person. And that means that the Clerk of the House and the Secretary of the Senate, when those reports for that person are not coming in, they're going to reach out and send a notice of noncompliance, both to the individual if they know where the individual is, but also to the organization that employed them, saying, look, you've got 60 days to correct this problem. Where are the LD203 reports? If that happens and somehow the former lobbyist is not responding, or even if they are, it makes sense for the registrant organization to kind of reach out to that lobbyist, get them to file the report that's due, but also for the registrant organization to take the steps necessary as soon as they can to delist that person as a lobbyist, because as long as they're on there, the system is still going to be expecting those LD203 reports. Have we lost anybody yet?
It is rather technical, but it's also rather important.
Right, because those notices get sent out that you can deal with them, but you got to be on top of them and deal with them actively. Don't let them fester from quarter to quarter, because at least technically, the Clerk of the House and the Secretary of the Senate give 60 days from when they issue a notice of noncompliance before they will or before they can refer the matter to the U.S. Attorney's Office for the District of Columbia.
Okay, so listen to what Rob just said there. They can actually refer this to the U.S. Attorney's Office for the District of Columbia, who then can take action against the lobbyist.
That's right. And I will say,
it has taken action.
It has taken action in very egregious cases of scofflaws, but they've actually also held, to a certain extent, held the registrant liable for lobbyist noncompliance too, in this context. So you stay on top of it. You delist the person as soon as you can. You get them out of the system, and then you're good. When you get a notice, get on top of that as soon as you can.
Okay, great. Now, there's another situation that we haven't discussed, which is oftentimes lobbyists leave one organization and go to another organization. And there are some tricks about that as well, because lobbyists could end up filing an LD203 under their previous organization. So that's something that organizations need to be on top of as well, as do the lobbyists.
Exactly.
Right? Yeah. So in those situations, the lobbyist needs to seek a transfer from its former organization to its new organization in order for the House and the Senate to actually identify that you have properly filed one of these reports.
Right. And we had a situation just like this come up with a client recently. And really, the best thing to do is to contact the Secretary of the Senate or the Clerk of the House and just tell them the situation, get them to do the transfer in the system there if you haven't done it somehow already.
I didn't know they were willing to do that. I thought you had to generate the request for transfer yourself.
Well, they will at least acknowledge the situation and understand and be on notice that the person has transferred.
Okay, that's great to hear. I didn't know it. All right, so we've talked a lot about, who needs to file and when you terminate and when you transfer. Let's actually talk about the reports now.
Yeah.
So tell us about the contents of the report. What actually has to go on one of these reports?
The first thing, obviously, the name and of the organization, the registrant, or the name of the individual lobbyist, that goes on there. First of all, these are electronically filed reports now, and so this is all done through filing in electronic form. And then there's a requirement to list any PAC, any political action committee, established or controlled by the filer. And for an organizational registrant, this would be a PAC connected to the organization, a separate segregated fund. Lobbyists, individual lobbyists, may also have to report and disclose a PAC, list a PAC here, if that lobbyist controls the PAC by, for example, serving as a board member or as treasurer of that PAC, unless those contributions of that PAC are already being disclosed on the connected organization's LD-203, and the individual lobbyist on his or her LD-203 notes in the comments section to that report that the contributions were previously or have already been disclosed or are being disclosed by the registrant.
So I will say this is an area where I find a lot of treasurers in particular who happen to be lobbyists do not identify the fact that they are the treasurer of a PAC and that their company has disclosed the PAC contributions on the LD-203.
Yeah.
So this is one where it just seems to get overlooked regularly.
Right. And obviously this gets us to the point, and it's implied by what we're saying, that you not only have to list the name of the PAC, but where there is a PAC that you're reporting, unless this exception applies, as I've said, for board members, you've also got to list the date, recipient, and amount of funds contributed by that PAC to any federal candidate or office holder, leadership PAC, not just any old PAC, but a leadership PAC.
A federal leadership
PAC. A federal leadership PAC, or federal political party committee registered with the FEC. If they aggregate of contributions to an individual recipient equals or exceeds $200. So the organization will have to do that for any connected PAC. The individual lobbyist will have to do that. Let's say they don't control the PAC, they're not on the board, not the treasurer. If they've made any qualifying contributions that fit the criteria I've just said, they're going to have to list those on their LD-203, individual LD-203 report.
So if they're making contributions in their personal capacity.
Yes. Now, it's important to emphasize here that even if these contributions have been appropriately reported by the recipients as they're supposed to be, and even if that reporting is on file appropriately with the FEC, they've got to still be reported if they meet these criteria on the LD-203 report. And as we will see, this is a favorite area of compliance auditing conducted by the Government Accountability Office in their annual audits of samples of the LD-203 reports.
So let me ask you a question before we move on to the next category. My experience with our clients is that many of them choose to report all their contributions, not just the contributions that fall within these categories.
Yeah.
What's your view of that? Is that a appropriate, acceptable practice, or should they really just report contributions to federal candidates, leadership PACs, and party committees?
Well, look, there's nothing illegal with over-reporting, but perhaps one thing we haven't said that we should emphasize, these reports are all publicly accessible. And that was another of the innovations under Haloga. There was, the Secretary of the Senate and the Clerk of the House were tasked with putting Lobbying Disclosure Act related forms, making them available, online. They're all available online now. So if you over-report, you're putting your contributions out there for the press and for others to look at and to ask questions about. That may be fine. Again, there's nothing illegal about it. But I would advise, unless you think it's more time than it's worth, I would advise taking the time to just list the contributions that are actually required to be listed. No point putting more of your life out there for scrutiny than you have to.
I'm fully in agreement with you about that. All right, let's move on to the next category, because there's 5 or 6 categories here of things that need to be reported.
Yeah, so I think we'll go through some of these. You may have plenty of questions, so please ask away. I'll probably bounce the questions back to you on some of them. But another important category is you got to list both the organization and the individual on the LD-203, the date, the name of the honoree or honorees, the payee, and the amount of funds paid for an event to honor or recognize a covered legislative branch or covered executive branch official. And this is an interesting one because the amount of funds paid for an event really should be read as, and is in the guidance, the kind of informal, non-binding guidance issued by the House and the Senate, is really elsewhere discussed as the amount of funds paid for the cost of an event. So that means, let's say, you pay for the room for an event, or you directly pay the caterer for an event. That would be paying the cost of the event. So that would be disclosable. But let's say it's a third-party event, and you're buying a table to the event, and there are many tables at the event. Under the clerk and the secretary's guidance, merely buying a table to an event, of tickets to an event, without more, is not going to be considered paying the cost of the event, because that's not going to turn you into a sponsor of the event. So even if you paid more for the table of tickets than you might have paying directly some cost of the event, the direct payment of a cost in the event has to be reported. Table of tickets by itself, no.
Okay, but this leads to an area of great confusion, I think, in the community. So many events have sponsors, so to speak.
Yeah.
A gold sponsor, a platinum sponsor, a silver sponsor.
Yeah.
And all they're getting is extra tables at an event.
Right.
They don't need to report. Is that correct?
Well, not just based on that designation.
Right.
They are a sponsor in terms of that's what you can call yourself, but they are not considered a sponsor of the events for these purposes. Here you would look really to the congressional gift rules. Who is a sponsor of the event under the ethics rules? Is it an organization that pays directly for the cost of the event? Often that's one organization paying and organizing the event, but there could be multiple sponsors, again, paying directly some expenses for the event. But simply by purchasing a platinum level sponsorship that's, 2 tables or 3 tables out of 100 tables, no, unlikely to be. Now, again, the guidance says by itself, right, that isn't it. If you have 10 tables and it's a 50 table event, maybe you are a sponsor.
Closer call.
It's a closer
Absolutely.
call. So
Absolutely.
it is a fact-specific analysis.
Okay. All right.
All right, so let's go on to another category here. You also, one of the other categories of contribution disclosures, and these are called contribution reports is reporting of the date, the name of honoree and or honorees, the payees, and amount of funds paid to an entity that is named for a covered legislative branch official or to an entity or person in recognition of such an official. What might that be? Well, there are some members of Congress, members of the Senate, who have had, let's say, libraries or, university programs or buildings named after them. Typically, it might be a library. If you have the Senator XYZ library, that's named for the senator. If you contribute to that, that contribution is a reportable contribution to an entity named for a covered legislative branch official. So that would have to be reported.
And oftentimes those are contributions to a university, right?
Yes, that's right. That's right.
So you would identify the university as the payee, but the individual member for whom it's named as the honoree.
Yeah, I mean, if you can fit it in the line, you might put Senator XYZ library at the University of so-and-so. But then as the honoree, Senator XYZ would be listed. That's right. So another category of disclosure is the date, recipient, and the name of the covered official, the payee, and the amount of funds paid to an entity established, financed, maintained, or controlled by a covered legislative or executive branch official or to an entity designated by such an official. So that may be, if it is an organization, there are a number of congressional caucuses, for example, that have related congressional caucus foundations. Many of the foundations have a number of members of Congress on the board. If there are a significant number of members of the board are members of Congress, covered legislative branch officials, that would be, and I think you agree that we would consider that an entity that is, first of all, it might have been established by, but it is also maintained or controlled by covered legislative branch officials, if there are members of Congress, say, on the board. I
definitely agree with that.
So that would fit under the category here. Also in this category, as I said, it talks about an entity designated by such an official. That doesn't just mean typically that, the member signs on to, a solicitation letter for a charity, or, their name's in the letterhead, or they sign a solicitation. If they are not somehow connected otherwise to the organization for which they're soliciting, that mere designation in that way is not going to, without other factors involved, that's not going to require disclosure here.
Okay.
Let's move on to the category of reporting that requires reporting of the date, the name of honoree and or honorees, the pay and amount of funds paid for a meeting, retreat, conference, or other similar event held by or in the name of one or more covered legislative branch or covered executive branch officials. I don't see this one very often.
I was going to say, I have never seen this one.
Yeah. I mean, first of all, these kind of co-sponsored events are not allowed, say, in the House anyway. So this comes up rarely, if at all. So
we're going to just skip right over it.
We don't have to spend any more time on that one.
Exactly.
And then this is one of my favorites. The date, the name of the honoree, the payee, and amount of funds equal to or exceeding $200 paid to each presidential library foundation and each presidential inaugural committee. What do you do for contributions to the Eisenhower Presidential
I was going to say, there are lots of presidents that have preceded us in life. And what do? I don't think those are reportable anymore.
They shouldn't be. And, the purpose, really, let's get back to why this LD-203 report was created and the requirement was implemented in the first place. It is to increase transparency of interactions between lobbyists with current government officials. So, which might indicate some back channel of influencing or indicate some context which someone could perceive as leading to improper influence. Let's get it all out there on the table so that any contributions to these members is known. For a deceased president, what is the what is the purpose there? It just doesn't meet the purpose of the requirement.
Okay, but how about the presidents that are still living? For instance, presidential library foundations typically happen after they leave office.
Yes. Oh, yes. Right? Indeed. Look, it's got to mean something. So I think I would draw the line. Living president, put it in there.
Yeah.
Deceased president.
No need.
I really don't see it. If the clerk or of the House or the Secretary of the Senate disagrees, give us a call.
I don't think they disagree with us on that one.
Now, one the question might arise that what about contributions to presidential transition organizations or contributions to the president-elect, vice president-elect? They are not reportable under the LDA because they are otherwise reportable under the Presidential Transition Act.
But those are reported by the entities receiving them, not by the givers.
That's right.
Yeah.
That's right. But those are not included here.
Small little favors.
Yes, even though, deceased presidents, but not these. Anyway, that's what the law says.
Well, but somebody's reporting these.
Yes, that's exactly right.
There you go. All right. Have we missed anything? I don't think we've missed any of the covered categories.
We haven't missed any of the categories, but look, some of these, as we said, particularly some of the first ones we talked about, again, we should emphasize they are fact specific. And, not to promote us too much, but we are here for our clients to help them if the situations are not clear to figure out, what does need to be reported and what doesn't.
Absolutely. And sometimes it can be a tricky call.
Right. Yeah. That's right. Yeah.
All right. You mentioned at the start of our podcast today that certain gift rules certifications are required. So why don't we talk about what they are?
Yeah. And to me, this is the biggest innovation on the LD-203 report. I mean, obviously, disclosure of these contributions was new. But the LD-203 report also requires all filers, organizational or individual, to certify twice a year the following. I certify that I have read and am familiar with the provisions of the standing rules of the Senate and the standing rules of the House of Representatives relating to the provisions of gifts and travel. I have not provided, requested, or directed a gift, including travel, to a member of Congress or an officer or employee of either House of Congress, with knowledge that receipt of the gift would violate Rule 35 of the Standing Rules of the Senate or Rule 25 of the Rules of the House during this filing period. So, if you do that, if you provide a gift in violation of the gift rules, you are now in violation of the LDA. If you fail to disclose, you're in violation of the LDA. And so this is
a damned if you do and damned if you don't.
And it really does put more of the burden of compliance. The consequences for an improperly provided gift are greater, really, for the donor than they are for the recipient in the House or the Senate, unless, of course, it's given with improper linkage. But so this is a very significant innovation, let's say. Obviously, it's been in effect now for almost 15 years, so you can't call it an innovation now, but it was at the time. And obviously, what this supports and what this requires, the ability for an organization, especially to certify to this, is that they implement a sufficiently robust regimen for training people in their organization about the gift rules, for tracking gifts that are given, for tracking gift rule compliance. Because, the individual who files this for themselves, they ought to know. It shouldn't be too hard for them to know and keep track of, although they also have to keep track of what they've done. But within an organization, twice a year, the person who signs this, and an individual has to sign this, has to have sufficient confidence that they are able to make these certifications accurately and truthfully. Which
is a big load to carry on your shoulders.
It is. It is. But if you have the right systems in place, you can do it. But you have to have confidence in those systems.
All right. Okay, I think I'm going to move on to HLOGA, mandating that the Government Accountability Office annually audit the extent of lobbyist compliance with the LDA and issuing a public report of that audit.
Yeah.
Can you tell us how the LDA compliance figures into that annual audit and report?
Well, the LD 203 compliance, most of the report is given over to compliance on the quarterly LD2 report. And for that, the GAO does select a sampling of usually about 100 or so registrants and looks at their LD2 reports and submits questionnaires, and they're picked randomly. Although if your organization has been picked a couple of years in a row, don't worry, it is random. And they ask certain questions, basic questions based on that report, and then follow up with an interview. On the LD 203 side, they also make a selection, a random selection of reports. They do that with, let's say, for the last year, for the report they issued in 2022, they reviewed 80 reports with contributions and 80 reports without contributions.
No, it's a lot.
Yeah.
I didn't realize it was that many.
It is a lot. I think they may have increased recently. And then they take a look at what's reported by the filers. And then they check those filers' names against the publicly available contribution database at the FEC. And so this is really the only area where of reporting, of information reporting under the LDA, where the GAO has an independent check of what's being reported. So they look at that. If there are discrepancies, they will then follow up with the entity or individual being audited and, ask for an explanation of that. Sometimes they're mistaken.
Well, they're mistaken often because of the change of reporting. So there's a difference between when somebody makes a contribution and when somebody else receives a contribution.
Right.
And so those dates are often going to change, and it's particularly acute when it's the end of a reporting period. So again, let's say you make a contribution on June 25th, but the candidate doesn't receive it till July 5th. It's in a different reporting period. And you might be asked about, well, why isn't that being disclosed by the candidate?
Right.
And of course, the answer is because they didn't get it until July 5th, and they're going to report it in the next reporting period.
Right. And one thing that, the GAO people ask about in their audits is, with respect to all the questions they ask, do you have any records supporting that disclosure? So, that's one reason to make sure you keep the records. But it's also important, and we advise, keeping these records for 6 years anyway. But you want to be able to show them, here's why it didn't show up on this. There's a discrepancy there. So keeping the records is really a very essential.
And I will say, oftentimes the record is a credit card bill. And you need to keep those credit card bills so that you can prove when you made your contribution. And those are where sometimes it's very hard to go back and find those records.
Right.
Because the credit card companies only keep them for 3 years or something for you to go back to. So you have to have them for 6 years.
Right. And of course, these are also records you may want to keep FEC purposes as well. So,
correct.
Many reasons why you want to make sure you have appropriate records of these kinds of contributions.
Well, I think we have covered a lot of territory today, a lot, and it's very confusing. We hope that we've given you some guidance and some highlights, and if you have any questions, we hope you'll reach out to us. But we thank you for listening, and we'll see you the next time.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create and receipt does not establish an attorney-client relationship.